Hello everyone, my name is Atiku Jafar, a Bapa 2 candidate at the Nigerian Law School Enugu campus and a virtual intern with Halim Solicitors. In the next couple of minutes, I'm going to be taking you through the legal and regulatory regime in the Nigerian telecommunications industry. Now, in every state that is exploring telecommunications competition, regulators and legislators have to consider how the market indices will play out, how industry operators are going to run their businesses, and how investors as well as consumers are going to be protected. The Nigerian telecommunications industry dates back to the reform, as it is today, dates back to the reform that was conducted in 2001. Prior to 2001, the entire value chain and infrastructure of Nigeria's telecommunications industry was fused into an integrated monopoly owned by the state called Nigerian Telecommunications Limited, NITEL. NITEL was inefficient and competition practices were barely non-existent in NITEL because it was practically a monopoly. The 2001 deregulation saw to the opening up of the sector to private investors and the commercialization of Nigeria's telecommunications industry. This deregulation saw to significant investments and surging demands for telecommunications services. Investments to the tune of $70 billion in 2019 were recorded since the sector was deregulated in 2001. Now, talking about the legal framework for competition or antitrust in the Nigerian telecommunications industry, we are going to be looking at respective legislations and agencies that are responsible for enforcing competition regimes in the Nigerian telecommunications industry. First, we are going to be talking about the apex regulator of Nigeria's telecommunications sector, the Nigerian Communications Commission, NCC. We are going to be using NCC interchangeably with the Commission at the course of this presentation. The NCC was established by the Nigerian Communications Act 2003, and the Nigerian Communications Act, otherwise called NCA abbreviated. The NCA provides under Section 4, subsection 1, paragraph D, that the NCC is responsible for promoting fair competition and preventing anti-competition behavior and abuse of dominant market positions among market operators. It is also responsible under the same section. The NCC is responsible for protecting communication service providers and facilities providers from misuse of market power and unfair competition practices by other facilities providers or services providers in the industry. The NCC is also responsible for preventing monopoly and ensuring that licensees do not engage in any acts whose intent or effect is targeted as substantially reducing competition in the industry. The NCC has used robust regulatory apparatus at its disposal, principal among which is its powers to issue subsidiary legislations under the Nigerian Communications Act, which we are going to look at in a couple of minutes. Now, the next legislation we are going to look at is the Constitution of the Federal Republic of Nigeria 1999 as amended, the ground norm and the foundation of all laws. Now, even though it is non-justiciable, Part 2 of the Chapter 2 of the Constitution, that's the fundamental objectives and directive principles of state policy, provide under Section 16, subsection 1A, and Section 16, subsection 2C, that monopoly and anti-competitive behavior in any aspect of the economy in Nigeria, which leads to an equal distribution of wealth among Nigerians, is strongly discouraged by the Constitution. Let's quickly look at the NCA, the Nigerian Communications Act, which I mentioned, 2003. It established the Nigerian Communications Commission as the apex regulator of Nigeria's telecommunications industry. And Section 70 of the NCA, that is a silver line in here, Section 70 of the NCA empowers the Nigerian Communications Commission to make regulations governing the telecommunications sector in Nigeria. Section 90 of the NCA further provides that the NCC is clothed with the exclusive competence to determine and administer, monitor and enforce compliance with competition laws and regulations as far as they relate to the Nigerian telecommunications industry. Section 91 also importantly provides that prohibits licensees operators in the telecommunications industry from engaging in any conduct whose intent or effects is targeted at substantially reducing competition in the industry. Now next, let's quickly look at the competition practices regulations. We mentioned that the NCA empowers the NCC under Section 70 to make regulations for the effective determination of its powers as a regulator in the Nigerian telecommunications industry under the Act. Now, in exercise of those powers conferred on it by the Nigerian Communications Act 2003, the Nigerian Communications Commission has issued or enacted the Competition Practices Regulation 2007. It has 37 regulations, and the objective of that regulation is to provide a regulatory regime for competition and consumer and protection of investors and market players, market operators against unfair practices, unfair competition practices. Regulation 23, very importantly, of the Competition Practices Regulation 2007. Regulation 23 of the 2007 regulations provides that the NCC may direct any licensee that is seen to be in a dominant position, dominant market position, to cease and desist from such conduct. The legal regime for competition in the Nigerian telecommunications industry would have been a lot easier if these laws that I mentioned and the institutions are the only ones responsible for regulating competition in the sector. In 2019, now this is the practice that had prevailed prior to 2019. In 2019, the Federal Competition and Consumer Protection Act was enacted and passed into law and duly assented to by the President of the Federal Republic of Nigeria. The Act was enacted to promote competition and consumer protection at all levels across all sectors of the economy. It has a broad spectrum and a wide-based application. It is targeted at eliminating monopolies and unfair antitrust practices, abuse of dominant market positions, and merger control. Also under the Federal Competition and Consumer Protection Act 2007 is that it has repealed merger control provisions that was under the Investment and Securities Act 2007. It has abolished the provisions that related to merger control under the ISA 2007 and enacted them under the Federal Competition and Consumer Protection Act 2019. It also established the Federal Competition and Consumer Protection Commission as a broad-based regulator. Under Section 17A to Z of the Act, the functions of the Commission are spelled out and are across a long line, but they can be summarized, basically, to include promoting competition, merger control, and consumer protection across all aspects of Nigeria's economy. The Act further established the Federal Competition and Consumer Protection Tribunal. It is a very interesting act. The powers of the tribunal under the Act, under Section 30 and Section 47 of the Act, the Federal Competition and Consumer Protection Act, includes powers to entertain all disputes relating to the administration and implementation of the acts, and the powers of the Federal Competition and Consumer Protection Act as a regulator. Now, this jurisdiction of the tribunal may be seen to have been perhaps in conflict with Section 251 of the Constitution of the Federal Republic of Nigeria, that vests exclusive jurisdiction on the Federal High Court to adjudicate over matters that relate to competition to the exclusion of all other courts. But hopefully that will be a topic for another day. Now, under the powers of the tribunal, it entertains appeals from the Federal Competition and Consumer Protection Commission's decisions, and it entertains appeals from decisions of any regulator that is established by any act of the National Assembly or the law of a state to regulate a particular aspect of Nigeria's economy. Let's look at quickly a case study. In 2015, MTN Nigeria Telecommunications Limited offered a bid to take over Visaphone, one of its major competitors. Emerging Markets Telecom Services was dissatisfied by this attempt to take over Visaphone by MTN. EMTS was formerly known as, it was the former Etisalat that we used to know. It dragged MTN before the Federal High Court, and the Federal High Court declined jurisdiction on the basis that emerging markets telecommunication services had not exhausted domestic fora or domestic remedies, that is going through the Nigerian Communications Commission, passing through the dispute resolution frameworks that were provided under the NCA 2003. Now, subsequently, the NCC later approved the takeover of Visafone by MTN, and MTN was enabled, as a result of which MTN accessed the wide spectrum of Visafone and leveraged on it, and also subsequently launched 4G LTE, the fourth generation long-term evolution services. Hopefully this conflict is going to be resolved, and I'm going to talk about that in my conclusion quickly. The regulated industries under the Acts, the Federal Competition and Consumer Protections Acts, are simply any industry subject to the powers of a regulator under an Act of the National Assembly or a law established by the State House of Assembly of any state of the Federation, be it the power sector, the food and drug sector, the telecommunication. It's a broad-based act that applied to all aspects of the economy. And the act further provides that where there is a conflict between the powers or the activities of the Federal Competition and Consumer Protections Commission and any other regulator, including the NCC, the FCCPC, the Commission, shall supersede. Now, having stated this, flowing from the above, it is clear that now these are the, in a nutshell, this forms part parcel of the legal framework for Nigeria's telecommunications industry, for competition in Nigeria's telecommunications industry. But what can be gleaned from our discussions above is that there is a clear duplicity and proliferation of regulation which will result into multiple regulations if implemented. While on one hand we have the NCC that provides for the powers, the NCA 2003 that provides for the powers of the Nigerian Communications Commission as the apex regulator to the exclusion of all other agencies over the telecommunications industry, and also empowers to regulate competition in the same industry. We have the 2019 Federal Competition and Consumer Protections Act that empowers the Federal Competition and Consumer Protection Commission to administer anti-competition regulations over all aspects of Nigeria's economy, including telecom sector. And this is going to breed multiple regulations, and it's going to breed so many uncertainties because market operators are going to be faced with the difficulty of conforming to multiple agencies having perhaps divergent standards for them to comply. Now, the waters have not been tested yet as to a conflict between the FCCPC and the NCC, Nigerian Communications Commission. But hopefully when the time comes, when they disagree eventually, which I'm fairly certain they will, perhaps they will be resolved. These issues, inconsistencies are going to be resolved across the table, just like the NCC did with the Nigerian Environmental Safety Regulations and Enforcement Agency over the clashes they had over minimum setbacks a couple of years ago. Hopefully, we are going to push for reforms to streamline regulations of telecommunications competition in the industry so as to have a robust and efficient competition regime in the Nigerian telecommunications industry. Thank you very much for your time.